recently published the 4th edition of his seminal work, Public International Law, A Practical Approach by Sweet and Maxwell. Okay, the title for Prof. Abdul Ghaffur presentation for today is A Microcosm of the Israeli-Palestinian Conflict. Okay, let us now proceed with the presentation by Prof. Abdul Ghaffur. Prof, you are muted.
Okay, Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alameen. So our respected Dean, fellow panelists, and ladies and gentlemen, Assalamu alaikum warahmatullahi wabarakatuh, and a very good morning. So thank you, Mr. Coordinator, Dr. Yazid, for introducing me. So the title I'm talking about today is The Case of Sheikh Jarrah, a microcosm of the Israeli-Palestinian conflict. Okay, so this is these are the contents of my presentation. And first of all, I would like to highlight my primary focus. My primary focus is legality and international law of the evictions of Palestinians from Sheikh Jarrah, East Jerusalem. And the case of Sheikh Jarrah is a microcosm, meaning that it is like a miniature that mirrors the entire Israeli-Palestinian conflict. It is a miniature that mirrors the injustice created by the Israeli annexation of East Jerusalem. And Sheikh Jarrah is a strategic area which is very close to the holy sites, Dome of the Rock, Masjid al-Aqsa, and the Temple Mount. So this is the Dome of the Rock. And then we have, this is Masjid al-Aqsa. And this is Temple Mount, al-Haram, al-Šarif. This is the Dome of the Rock, and this is Masjid al-Haram. And Jarrah is very close by to these holy sites. And this is very important for the Palestinian as well for the Muslims all over the world. Sheikh Jarrah is at the heart of the current conflict. Why Sheikh Jarrah is so important? You can see the map here, right? Sheikh Jarrah. And you can see the East Jerusalem settlements. The purple color ones are the Israeli settlements, and the brown color ones are the Palestinian areas. And Sheikh Jarrah is, I think, the last fortress for Palestinians to cover the Masjid al-Aqsa and the holy sites. So that's why it's a predominantly Palestinian neighborhood in East Jerusalem. And why this name Sheikh Jarrah, we got the name Sheikh Jarrah, it is taken from the 13th century tomb of Sheikh Jarrah, a physician of Saladin. And as you all know, East Jerusalem was under the Jordanian rule in 1948 until 1967, the 60 War. And in 1956, the Jordanian government moved 28 Palestinian families into Sheikh Jarrah. You all know that they were displaced from their homes in the Israeli-held Jerusalem during the 1948 war. They were settled in Sheikh Jarrah by Jordanian government. And this settlement by the Jordanian government of an agreement between the Jordanian government and United Nations Relief and Work Agency for Palestinian Refugees, UNRWA. There was an agreement. There is an agreement. The agreement is between the government of Jordan and the international organization UNRWA. Something like it is a treaty between the government and an international organization. And in this agreement, so there was a give and take. So the refugees, the Palestinian refugees, they will renounce their refugee status. They will lose all the aids and all the food given by the UNRWA in exchange for the title for ownership. So, title for ownership of the new houses built by UNRWA together with the Jordanian government in Sheikh Jarrah after 3 years of residency. This is the agreement between Jordanian government and UNRWA. But unfortunately, the official transfer of ownership did not take place. Maybe this is due to some technical problems or due to the lack of interest on the part of the Jordanian government. This is a big headache later on. In 1967, Israel occupied East Jerusalem, including Sheikh Jarrah. In the beginning, the Israeli Minister of Justice impliedly stated that the deal with UNRWA would be respected. But unfortunately, later on in 1972, this is the first claim, the Sephardic Community Committee, the Israeli settlers group. They went to court, Israeli court, to contest the ownership of the property in the Sheikh Jarrah. So this is the first, case before the Israeli court for this dispute, Sheikh Jarrah dispute. Okay, so now, after this, after 1972, there are a number of the cases before the Israeli court, especially the Jerusalem District Court, for the evictions of Palestinians from Sheikh Jarrah. And these unjust evictions were on the basis of apartheid or discriminatory laws. Okay, discriminatory laws. Government, these eviction cases are merely a real estate dispute. It's a property dispute between. So they tone down this as just a real estate dispute between private parties. But for for Palestinians, this is a part of the Israeli strategy to Judaize East Jerusalem. And this is against international law of the Palestinian residents. And this is a type of ethnic cleansing. And in October 2020, the Israeli court issued a decision to forcibly evacuate Palestinian families residing in Sheikh Jarrah and to transfer the ownership of their homes to Israeli settlers. This is actually the underlying cause of the current 2021 conflict. Okay. So, and then under the order of the Israeli District Court, 4 Palestinian families must evacuate by May 2nd, 2021. Otherwise, the Israeli authorities will forcibly evict them. This is the first order. The second order is another 4 families have to evacuate by August 1st, 2021, and they have to also to face with forced eviction. Okay. The Israeli families appealed to the Supreme Court of Israel, and the Supreme Court expected to deliver a ruling on 10/21. But because of the violent clashes in East Jerusalem, especially Jerusalem, the court delayed the expected decision on eviction for 30 days. This is also due to intervention from the Attorney General because of the sensitivity of the case. Okay, now let us see what are the apartheid laws or discriminatory laws, which are the underlying cause of this unjust evictions or anticipated evictions. So there are two unjust laws. Number one, the first law is we call the absentee property law of 1950. The absentee law. This is after 1940. And under this situation, they issue a temporary law because this is based on state of emergency. They adopted called the absentee property law in 1950. And according to this law, the Israeli may give to Jews the property of Palestinians who fled during the 1948 war. So they will be declared absentees, and then the government will give all these properties and homes and lands to Jews. This is the absentee property law of 1950. And the other law is the law on the legal and administrative affairs 1970. So this is after the Six-Day War in 1967. Israel adopted this law. And according to this law, Jews who lost their property in East Jerusalem, including Sheikh Jarrah, they can reclaim their property from Palestinians. Okay? So the law, on the other hand, does not allow Palestinians to reclaim their property or their land or their houses, what they lost in Israel in 1948. That's why we are calling this extremely discriminatory and apartheid law. Because Jews can reclaim their property, their old property they lost, but Palestinians cannot reclaim their property, what they lost in 1948, before 1948. Okay, we call the discriminatory, and why evicting Palestinians from Sheikh Jarrah will create double injustice for Palestinians, double injustice. The people whose East Jerusalem homes now claimed by Jews are the same people who had their homes given away and lost their homes to Jews because of the absentee property law 1948. And they had fled, and then they had to settle down in East Jerusalem, which was controlled by Jordan, and Jordanian government, by agreement with UNRWA, they has given them homes in Sheikh Jarrah. So the land was given by Jordanian government, and the funding for construction of the houses were given by UNRWA. So this is the agreement. Okay, now how this double injustice works? The law from 1950, absentee property law, took whatever has been houses and homes of Palestinians where they own in previously, they live in. And then the law from 1970 allow the Israeli to claim homes, Palestinian homes, where they are currently living in, with no compensation, with no alternative housing, no remedies at all, no redress at all. They have to just to be evicted from their homes. And then should the Supreme Court allow the eviction orders, so it would make all the residents, Palestinians from Sheikh Jarrah, including all the elderly grandparents, all the small children, they become homeless, they become helpless by virtue of these Israeli apartheid discriminatory laws. So now we're demanding justice. Demanding justice. It's quite natural that the Supreme Court of Israel would apply Israeli law only. But in the interest of justice, we are now urging the Israeli Supreme Court to consider the following facts. The first one is 1970 law is discriminatory and apartheid in nature. That's why you should sparingly use it. If possible, do not use the law. Second, should reconsider the submission by Palestinian lawyers. Palestinian lawyers claim that the submitted by the Jewish settlers are forged. They are not the original documents, and they connected with the Turkish government, and they got the original ownership documents from Ottoman land archives in Ankara. This is what is claimed by the Palestinian lawyers. But anyway, the Supreme Court should not just reject these claims by Palestinian lawyers, and they should reconsider these claims by Palestinian lawyers that there are original ownership documents, and according to these documents, the original owner in the 19th century were Palestinians, not the Jews. Okay. The third point is, should respect the binding agreement between the government of Jordan and the United Nations Relief and Works Agency. Okay. According to this agreement, after 3 years of residency, the legal ownership of the property would be transferred to Sheikh Jarrah Palestinian family. This is an agreement, an international organization, binding agreement. So Israeli Supreme Court should respect the agreement between Jordanian government and UNRWA, and should respect the clear international law position that East Jerusalem is an occupied territory and not under the sovereignty of Israel, and no Israeli laws are applicable in East Jerusalem. So now, let us look at the international law position. What is the international law position? So we have to look at from two aspects, two key considerations. The first one is the legal status of Jerusalem, and the second one is violations of IHL. First, the legal status of East Jerusalem. This is all international law scholars know very well, that East Jerusalem is actually under belligerent occupation. And this is reaffirmed again and again next by Israel. And then the ICJ, the World Court, confirmed the applicability of the IHL and IHRL to East Jerusalem. And then we have a very important the international law, there's a laws and customs of war, Article 43 of the Hague Regulations. The occupying authority, now Israel is the occupying authority. So Israel occupied these territories. Israeli is the occupying authority, even though they have the most important point here is they must respect the laws, the existing laws enforced in the country, in the territory. They must respect the existing laws which is enforced in the country. So that's why under international law, Israel does not possess sovereignty over East Jerusalem. Israel is not entitled to apply its own domestic law in East Jerusalem, including Sheikh Jarrah. And Israel has to respect the current existing law, Palestinian laws or Jordanian laws, which are applicable in East Jerusalem, and cannot arbitrarily change the laws. And then there are numerous United Nations Security Council resolutions on the status of East Jerusalem. So I will highlight here a few resolutions only. Resolution 298/1971 very clearly confirms that all the legislative and administrative actions taken by Israel to change the status of Jerusalem are totally invalid. 14 votes to none, one abstention only. Negative vote. And Resolution 465/1980 to the same effect, and it was adopted unanimously. Even USA supported this resolution. And Resolution 478/1980 is a very important resolution, and affirms the enactment of the Israeli law. Jerusalem, capital of Israel, as the capital of Jerusalem, constitutes a violation of international law. And then the Fourth Geneva Convention still applicable in the occupied territories, including East Jerusalem. And the Security Council unanimously determined that all legislative and administrative measures made by Israeli are null and void and must be rescinded forthwith. And then decide then not to recognize the basic law of Israel to change Jerusalem as its capital. This is the principle. The fifth paragraph is the principle of non-recognition of an illegal act, an act which is not legal under international law. All states, all member states must not recognize this as legal. So this is the principle of non-recognition. And all these resolutions are binding, legally binding, by virtue of Article 25 of the UN Charter. They are legally binding and also binding on Israel. Okay, very well. Now, the application of IHL. So we have seen very clearly the applicability of IHL, in particular the Fourth Geneva Convention, the civilian convention to East Jerusalem, including Sheikh Jarrah. And it was confirmed by the Conference of High Contracting Parties, all the most important, the highest organ of the Fourth Geneva Convention adopted that, the de jure applicability of the Fourth East Jerusalem. And this is also reaffirmed in the Palestinian War Advisory Opinion. Then what are the provisions of the Fourth Geneva Convention, which is violated by Israel in East Jerusalem? So number one, Article 49.1 of the Fourth Geneva Convention, 1949, transfer of protected persons from occupied territory, forcible transfer. And here, the Palestinians in Sheikh Jarrah, they are civilians, and this is the civilian convention. So protected person means civilians, and thus they are protected persons. And forcible transfer includes the abandonment of homes and potentially losing one's right in the property. That's why we can see very clear violation of this Article 49, Clause 1 of the Fourth Geneva Convention in Sheikh Jarrah. Number two, Article 49, Clause 6 of the Fourth Geneva Convention. The occupying power shall not transfer parts of its own civilian population into the territory it occupies. Now, with regard to this Sheikh Jarrah, this provision also has been violated by the Israeli government.